An Arizona man is in custody accused of killing his wife and attempting to conceal her body. Prosecutors say 56-year-old Brandon Gregory admitted to beating his wife with a baseball bat. Her body was later found in a car with Gregory more than 100 miles away from the couple's home. The victim's family is now asking the court to keep him behind bars permanently as they step in to care for the couple's 2 children. I'm Kennedy Walker, and I'll walk you through the details.
Brandon, I hate you forever. I hope you never, ever, ever get out of prison.
Emotional words from the mother of Allison Gregory, the woman police say was beaten to death by her estranged husband.
We ask you to please keep him locked away from our family and society.
56-year-old Brandon Gregory stood before a judge in a Surprise, Arizona courtroom charged with murder.
The brutality of this case is alarming, Your Honor.
Behind the doors of this home, prosecutors say Gregory struck his wife, 41-year-old Allison, multiple times with a baseball bat during an argument.
Allison struggled so hard to get away from him, and she was so close to it.
The couple was in the final stages of divorce and preparing to sell their home in Surprise, Arizona. That's about 40 minutes northwest of Phoenix. Police say after the attack, Gregory placed Allison's body inside of her own car, then drove more than 100 miles to a remote campground. According to police, it was Allison's mother who first contacted authorities after her daughter failed to pick her up from the airport. When officers entered the home, they say they discovered blood on the walls. Police used license plate readers and tracking technology to locate Allison's car, eventually finding it with Gregory inside, along with her body. While in custody, investigators say Gregory confessed to the killing and reportedly wrote apology letters to his daughters. In court, Allison's family pleaded with the judge to keep Gregory behind bars.
The guy's entire life has been a lie. He's a manipulator, and now he's a murderer.
And her mother had strong words for her son-in-law.
Brandon, I hate you forever. I hope you never, ever, ever get out of prison.
Gregory now faces multiple charges, including second-degree murder, manslaughter, concealment of a dead body, and tampering with evidence. Allison's family has launched a GoFundMe to help care for her 2 daughters who were left behind in the wake of tragedy. And joining me to talk more about this is criminal defense attorney Aaron Reed. Aaron, thank you so much for coming on today. Let's jump right in. So you've seen the court filings and heard the emotional testimony. What stood out to you in this case?
Well, first of all, thank you so much for having me on. This case is very unique in that you don't really see this kind of brutality even amongst people that don't really know each other, and a baseball bat being used in the way that it was used. It's very brutal, very graphic, and obviously there was some sort of a disagreement that escalated to that point. And it's very sad and tragic that Mr. Gregory had to feel that he felt the need that he needed to do that in that moment. But what stood out to me was just the sheer brutality of the attack.
Right. And we often talk about domestic violence as something that escalates. Does this case follow that pattern legally or emotionally?
Well, certainly it fits it as far as what I've heard and read online about these proceedings, and it was supposedly a really nasty, contentious divorce, and there's underpinnings of prior domestic violence. Obviously, I don't have proof of that or know that. The people that are investigating, they're going to have that information, but it certainly looks as though this was some sort of an escalation from past domestic violence, and we see that quite a bit in this country across all different states. That's how the progress is, right? It goes from a push to a hit, then eventually you snap and something like this happens, and it shouldn't happen. It's tragic.
And when you see a murder charge filed in a domestic situation like this, is it usually a second degree or could it have been more severe?
I think it depends on the facts of the case. Certainly this situation appears that something just snapped in Mr. Gregory's mind at that moment, which would indicate to me a second degree murder charge. It doesn't appear that he did it with any sort of premeditation. I know that Miss Gregory had a bat in her hand, and it appeared that they had been fighting. So it sounds like this is what we call a sudden quarrel or a heat of passion type of situation, which would be a second degree murder charge. But there are domestic violence situations that we've seen that are much more severe as far as the premeditation or planning or trying to execute a spouse or something like that, that would be a first-degree murder type of case. But I think the appropriate charges here are second-degree murder.
And for second-degree murder, if you could just walk us through what prosecutors have to really prove for that charge to stick.
Sure. So in Arizona, second-degree murder is the intentional killing of another human without premeditation. And I think certainly multiple blows from a bat to a woman that was unarmed is going to indicate that he's intending to kill her. I don't know any of the details as far as the autopsy or the wounds or any of those kinds of things. I would expect that those sorts of facts. The autopsy report is going to shed a lot of light on the exact injuries that she sustained, which could then be used to say that this was an intentional killing. It's one thing to hit someone with a bat once, maybe you're disarming them, maybe they're coming at you, but to repeatedly strike over and over, I think that's where prosecutors will hang their hat and say that crossed the threshold from a situation where it was rage into an intentional killing.
Right. And he isn't only charged with that. The suspect is also charged with manslaughter, concealment of a body, tampering with evidence. How much weight do those charges carry?
So the manslaughter charge is kind of a lesser included of that second-degree murder. They charged it both based on that sudden quarrel or heat of passion, but there's a significant difference in the punishments that a person can face for manslaughter versus second-degree murder. As far as the concealing of a body and the lesser charges, those really won't play into a punishment if Mr. Gregory is eventually convicted, either at trial or through a plea agreement. The main charges that a jury will be considering, or a prosecutor through a plea agreement, would be weighing that second degree versus manslaughter. And that would be, I think, the primary focus.
So is it normal, would you say, to see all of those charges stacked together like this, or does it just signal something about how prosecutors are approaching the case?
I think it's pretty normal. There's a lot of times prosecutors, they look at a case and they will start with the most severe charge that they think they can prove, and then they work their way down based on the evidence that they collect from the police departments and from the investigators. And those pieces of evidence and the reports and things like that indicate what charges the prosecutors are going to pursue. So most of the time it is based on the evidence. And you see some cases where there's 30 or 40 charges. You see some cases where there's one or two. But it just certainly depends on the evidence of what they have and what they can prove, because they have to prove each charge beyond a reasonable doubt, and they have to have a basis to file each charge.
Is there any chance that Mr. Gregory could argue self-defense or heat of the moment, or is the evidence just too overwhelming?
I think he probably could argue self-defense. I know there was a mention about her, I think, kicking him in the groin, and she had the bat initially. I do think that could be an argument that a defense attorney could make. The problem is going to be, once he has the bat, is there an immediate threat to him that would warrant him using the bat in self-defense? And I think that is where defense attorneys are going to have a hard time convincing a jury that what he did was justified under the situation. And even if he did get kicked in the groin, a kick to the groin certainly doesn't equate multiple blows with a bat, presumably to the head and upper body area, killing someone. So I think that's going to be the biggest problem. I would look to see if the defense attorneys cut a deal or try to cut a deal for manslaughter versus second-degree murder. I think that's where the focus will be.
If they do cut a deal, how many years could he be facing potentially if convicted?
So the difference between second degree and manslaughter is pretty stark. And second degree in Arizona is a range between 10 years and 25 years in prison, with the presumptive being right in the middle. And manslaughter, the range is 7 to 21, with the presumptive being 10 and a half. So the difference there is, for second degree murder, it's a flat sentence. It's a calendar, day for day. There's no early release. There's no kickouts. There's nothing. You have to do every day of the sentence. For manslaughter, it's an 85% eligible sentence. So you would do 85% of 10 and a half or 12 or whatever he ultimately gets. I think that's a pretty big difference when you're talking about years and years like that. So that's what I think prosecutors will focus on when in plea negotiations. That doesn't mean that they're going to get a manslaughter plea, but if I was a defense attorney with this kind of situation, I would probably be looking to get some sort of a manslaughter deal in place.
Absolutely. And let's just talk about the alleged confession. Police say that he admitted to everything and even wrote apology letters to his daughters. How does a written confession play out in court?
So a written confession is just like any other confession. If you're in front of a police officer, they're going to have to prove that the confession was voluntary and from Mr. Gregory, which isn't very difficult to do considering the facts and the circumstances surrounding this confession. The fact that he was addressing his children in the confession certainly points to him writing it, and then asking for forgiveness shows some sort of a guilty conscience or a guilty mind, and the prosecutors can use that and essentially read it right into the record in trial. They wouldn't need Mr. Gregory to take the witness stand or any of that. It would come in under one of the rules of evidence, and they would be able to essentially read it verbatim right into the record in front of the jury.
And in a case like that, if a suspect says that they want to write an apology letter to their child, because that could be considered, evidence, would the police or the DA, would they take that letter first and maybe make a copy of it before handing it over to family members, or it just depends on the situation?
Great question. I think certainly they're gonna impound it and take it as evidence. It'll probably be attached as a part of a police report for whatever officer or officers found the scene and then eventually found the body. And we're talking about two separate agencies because the body was found in a different county. It was found in Mojave County, just slightly northwest of Phoenix. But in my opinion, I think the copies could be made. I don't know if they're going to provide them to the family. The victims and the victims' next of kin certainly have a right to see all of the discovery. So as a part of the discovery file, the victims would see that letter and they are entitled to see it. I don't know if it would be provided to them. That would be a decision by the prosecutors and by the investigators to provide that information to the victims.
And it just seems like there's a lot of evidence stacked up against the suspect here. I mean, on top of that alleged confession, police also found the victim's body in the car with him. Does that seal the case, or is there still room for a legal fight here?
There's a mountain of evidence against Mr. Gregory. The destruction of the Apple Watch, throwing away the smartphone, the letter, the body. It's a very difficult case, and obviously the confession. So when you deal with all that mountain of evidence, as a defense attorney, I always approach every case as if it's going to trial until it's not going to trial. And I think this case should be no different. They should have an open mind reviewing the discovery to make sure that the police and the investigators did their job the way that it's supposed to be done. But if they did it and everything was fine and there was no issues, then it's going to transition into mitigation and plea bargaining, I think, pretty quickly.
And we heard powerful statements in court, especially from the victim's mother. She said, quote, "I hope you never get out of prison." Do those kind of victim impact statements hold any weight at this early stage?
In some form they do. When a person is arrested, if the victim is addressing the court for release conditions, and victims and victims' next of kin have a right to be present during every court date, and they have a right to have input on certain things, such as plea agreements, sentencing recommendations, and release conditions. And in this case, when he was arrested, he had to be taken in front of a judge and a bond imposed. And a judge will consider victims' statements at that point with regards to setting release conditions. So yes, the victims their statements would be considered by that initial appearance judge.
The family now has to raise a teenager without their mom. The victim's other daughter is not a minor. But in a case like this, does the system provide any support or resources for the kids?
There are victim services through all the different county agencies here in Arizona and Maricopa County Victim Services. They will help families. I know there's a victim services fund that helps families with costs of funerals, all those kinds of things. Sometimes they'll even pay for counseling. So there are resources to help. They're not outstanding, but they're at least something to help the family. At Maricopa County here in Phoenix, they do have those kinds of things to help out and assist where needed.
And just touching a little more on that, but just more going back to, the domestic violence or alleged domestic violence here. The family said that Allison had been trying to get away. How often do we see violence like this unfold as someone tries to leave?
I think that's the most important and deadliest moment in the relationship. Once you're away, you have a little bit of safety. You have a little bit of your mind is a little free, knowing that you're not in the same room or the same house with this person. And Allison seemed to just tell him, "Hey, I'm out. I want to be done with this. I don't want anything to do with you." And at that moment, that's the most dangerous situation to be in with previous domestic violence and an explosive partner. And certainly something happened between the two of them at that moment where she felt the need to arm herself with the bat just to even broach the topic or even get to that point. And that's the deadliest part of this kind of thing. It's very difficult for victims of domestic abuse to get out of the situation. I think a lot of people don't understand how difficult it is, especially in a marriage with kids. It's extremely difficult. It's not easy to just say, okay, well, you should just leave. It's not that simple in most cases. So it's very difficult to do.
Could previous abuse, even if never formally reported, come up in court?
Absolutely. Absolutely, it can. So in Arizona and in most other states, they can use a specific rule of evidence to bring up other bad acts or other act evidence that we call it. And those types of situations and those types of prior bad acts can be used to establish certain patterns and certain things that the jury can hear. So I do think if there is a pattern of domestic abuse that's documented in some way with some witnesses and some people that have seen it or heard it, I do think it will come in, especially if it goes to trial. And that will be something that the prosecutors will consider when making plea agreements as well. They're going to look at the fact that he has had prior run-ins with her, and that, like you mentioned earlier, this was an escalation of prior domestic violence. So yes, that will likely come in.
If this does go to trial, what does a timeline look like from here?
I would say a lot of that depends on Mr. Gregory and how fast he wants to go to trial. There are speedy trial rights. If he wants to invoke those, I would say he would be able to go to trial within 9 months or so, 6 to 9 months, although I don't think that's realistic. Most homicide cases, I think, take at least a year or more to get to trial. And sometimes it could be 2 or 3 years before it gets to trial, depending on situations and what's going on. It'll all come down to how hard he really wants to fight versus how hard he's trying to get a plea deal. But I do think if it goes to trial, we're not looking at a trial for at least another year.
Do you think the prosecution will push for the maximum on all counts or focus on the murder charge?
I think if it were to go to trial and he were to be convicted, I do think the prosecution would ask for the maximum on all the charges. Certainly the victim's next of kin and her family is going to ask for the maximum that could possibly be imposed. And I think that there's a possibility that it could happen. I mean, it just depends on this pretrial process and this plea negotiation process. As far as a plea is concerned, I do think if he does get a manslaughter plea, it certainly won't be on the lighter end of the range. I think it'll be on the higher end of that range at 7 to 21 years. I'm thinking somewhere between 11, 12, 13 on up to 21. And in a lot of these cases, these prosecutors, they like to make plea deals that have ranges built into them so that the judge is the final say as to what that punishment is. And that means that the victims have a chance to come in and argue what they believe is a fair sentence. So I do think prosecutors will be asking for the maximum, regardless of whether they go to trial or under a plea agreement.
And I know you just mentioned how many years he could serve potentially for the manslaughter, but if it is second-degree murder that he is convicted of, could he be eligible for parole one day, or is that usually off the table with second-degree murder?
In Arizona, second-degree murder is a flat time sentence. So there's no parole, there's no early kickouts, nothing. So if he were to be sentenced under the statute for second-degree murder, he would be in for every single day of his sentence. So he would not be released.
Well, this is something that we will be following very closely. Thank you so much, Aaron, for coming on today.
Oh, thank you so much for having me.
Allison is remembered as joyful, passionate, and a loving mother. She was a Navy veteran who loved the outdoors and cooking. For Law and Crime, I'm Kennedy Walker.